Hello, thank you for joining us today and welcome to our Trademarks webinar. My name's Catherine Ripley. I'm a partner at Field Seymour Park Solicitors in Reading, and I lead our commercial and technology team, which advises on a range of commercial contracts as well as on data protection and intellectual property issues. Before we start today's webinar, there are a few housekeeping points I should mention to you. First of all, as you may be able to tell, we're running the webinar remotely. We aren't expecting any interruptions from children or pets, I'm pleased to say, but it's possible that we might have the odd technical glitch. Hopefully there won't be any problems, but if there are, then apologies in advance. Please bear with us and we'll try to resolve them as quickly as we can. If you have any difficulty joining the webinar at your end, you might like to try coming out of it and rejoining, as sometimes a refreshed internet connection can sort of do the trick. Everyone apart from the speakers is on mute today, but we'd really like your comments and questions. So please leave them in the question box that you'll see on screen. The webinar is due to last about an hour. And within that time, we'll have a Q&A session after the presentation when we'll try to answer as many of your questions as we can. If we run out of time and there are any questions that we haven't got around to answering, we'll follow up with you individually by email afterwards. We'll be conducting a few sort of fun polls during the webinar, so please do get involved in these, not least because it's nice for us to know that there are people out there listening to us. A fuller version of the slides that you can see on screen can be downloaded from the handout section on the screen, or please ask us to send them to you afterwards. If you don't already know us, our email addresses can be found on our website at www.fsp-law.com. We're recording the webinar today, and the recording will be sent out to all attendees later today. So please feel free to pass it on if you have colleagues who might be interested. And finally, would really appreciate your feedback on today's webinar. So please complete the short survey that will appear on the screen at the end of the session. In particular, if there are any topics that you'd like us to cover in future webinars, please let us know. All the surveys that are completed will be put into a prize draw for £50 worth of John Lewis vouchers, so please do take part. I think that's all on the housekeeping. So today's session is going to be an introduction to the process of applying for and registering trademarks. The process is something that we do very regularly, and it's usually quite smooth, but sometimes there can be the odd road bump on the way. And so today's session will cover many of the common issues that can arise, and we'll share with you our suggestions and experiences as to how these can be overcome. The session today is going to be broken down into a few different sections. First of all, Susan Wells, who's one of our associates, will look at the preliminary issues to consider before filing a trademark application. And then we turn to Francesca Lombardi and Charlotte Burrows, who are both solicitors in the team, and they're going to take it in turns to run you through the process of making a trademark application and explaining what happens after the application is filed with the UK Intellectual Property Office, which is a bit of a mouthful, so we may also refer to it as the IPO or the IPO. Before I hand over to the rest of the team, I thought it might be worth me spending a few moments just to set the scene by explaining briefly why trademarking actually matters. Branding is obviously something which is around us, you know, all the time, and it often amazes me how even young children are able to recognize all sorts of logos in a flash. I think you can even get games based on nothing more than being able to identify logos. But away from the big household names like Coca-Cola and Facebook and the like, why is branding and trademarking important to smaller businesses? Well, for any business, a brand acts as an indicator of the origin, an indicator as to the origin and the quality of the brand owner's goods and services. It helps to make the goods and services stand out and gain greater recognition in the market. So it can make you more distinct from your competitors and from their businesses. This in turn should drive interest in your business and consequently improve sales. So a brand can be a really valuable asset, and it ought to be properly protected. From a legal perspective, there are two reasons why protection matters. Firstly, by registering a trademark, there's a public record of your ownership. So if other people search the IPO website before adopting a brand name and they come across your trademark, then they may be deterred from trying to take advantage of your trademark or using a trademark which is similar to yours. So registration has a sort of deterrent effect. Or even if a third party does use the same or a similar trademark to yours, having a registration should make it easier for you to challenge their usage in appropriate circumstances, as opposed to bringing a common law claim for passing off, which can be much more tricky. Secondly, a registration can also help you to demonstrate the value of your brand as an asset of the business. For example, if you come to sell a business or seek investment, a buyer or investor undertaking due diligence on your business is likely to be reassured if you've got everything in order and you've registered your key brands as trademarks. Conversely, if an important trademark of the business hasn't been registered, a prospective buyer could use the fact it hasn't been registered as an excuse to try to chip away at the price. So that's the theory. How do things work in practice? At which point I'll hand you over to Susan. Thank you.
Thank you, Catherine. Hello, everyone. So today we'll be using a hypothetical client to demonstrate the issues that may appear throughout a trademark application. I have to admit that our client for today might have been influenced by our want for warmer weather, but let me introduce to you the Bristol Barrel Limited, where you can find perfect surfing all year around. So a little bit more detail about this company. So the Bristol Barrel is an inland surf destination where you can find a variety of waves to suit all levels of surfer, from beginner to expert. So they are licensed to use a certain type of technology that can generate up to 1,000 quality waves per hour, ranging from 50 centimeters to almost 2 meters in height. And they can produce a new wave every 8 to 10 seconds. So you can see why this surf center is a welcoming sight for some, as good waves are guaranteed, no matter what the tide or other ocean conditions you normally need to take into account for a decent set of waves. So they also offer surf lessons for beginner surfers, so delivered by the team of qualified coaches. And they also offer non-guided surf sessions for intermediate and advanced surfers who are already confident on the board. They have a surf shop where you can buy surfwear, wetsuits, surfboards, and surf wax with experienced staff to help you choose the right fit for your experience level. So now you know a little bit about the client for today. So Bristol Barrel wants to register a trademark, but they do not know what they can actually register as a trademark. So next we're going to look at the following forms of marks that can function as a trademark, and I will also give you an example of each of these. So you can register a word like Kodak. You can register slogans like just do it for Nike. You can register designs like the 3 stripes for Adidas. You can register letters like RBH. You can register numerals, so 501 jeans. You can register internet domain names like google.com. You can register the shape of goods or packaging like the prism of the Toblerone chocolate. You can register smells, so the description of a perfume. You can register sounds, so a 4-note musical jingle has been registered in the past. You can also register colors. So Heinz registered the color turquoise for use on its tins of baked beans. And you can register gestures. So Asta registered the double tap on the back pocket of customers' jeans as a trademark. And then you can also register moving digital images. So Intel's Sleep Ahead logo has been registered. So Bristol Barrel is now comfortable with what can function as a mark, and they now need to come up with a mark of their own. So there are 2 important things that they need to keep in mind when designing their mark. So firstly, they need to make sure that the mark is distinctive and not merely descriptive. And they also need to ensure that it's not similar to another mark already registered. So firstly, we're going to take a closer look at the distinctiveness concept. So legislation prohibits the registration of marks devoid of any distinctive character or marks that indicate the characteristics of the goods or services with which they are associated. It is therefore difficult to register a descriptive mark, and you will have a better chance of success if you can come up with a unique and made-up word, or if you use an existing word which dictionary meaning has nothing to do with the actual goods or services to be covered by the mark. So just looking again at our early examples, both Kodak and Adidas are unique words that are immensely popular, and Apple is a good example of an existing word used in connection with unrelated goods and services. It is, however, often the case that the simplest designs can be the most effective. So on the next slide, you will see a red triangle, which belongs to a brewery in England. So this mark was registered in 1876 when the new Trademarks Registration Act came into force. So we're going to do our first poll for today. So on the screen, you will see 4 names. So if you can please choose who do you think this red triangle mark belongs to. So that those are 4 examples of breweries. So please choose the correct name. And we'll give you a few seconds to do that. Okay, it looks like most of you are on the right track. Okay, so it looks like 67% of you voted for Bass, so well done. That is correct. So Bass was registered in, it was registered in 1876 by William Bass, who founded the company in 1777. So really an old trademark, and it's definitely one of Britain's most recognizable marks. So other examples of simple but yet effective designs are the 4 connecting rings of Audi and the golden arches of McDonald's. So whether a mark is distinctive or not will be assessed by the goods and or services to be covered by the trademark. So again, Apple is a good example to use here to demonstrate this point. So on the next slide, we can go there. It would not be possible for Apple to use a trademark to cover apples because it is used for something completely different. It is considered distinct. So another example of descriptiveness would be to register the word bakery to cover baked goods such as breads, cakes, pastries, etc. So this type of application will be rejected by the IPO. So just looking again at Bristol Barrel, so they might actually have an issue with distinctiveness if they're interested in registering Bristol Barrel as a mark, considering that barrel is often associated with waves and surfing. It refers to the hollow part of a breaking wave. So this is maybe something the beer and wine drinkers are not actually aware of. So Bristol Barrel may want to come up with a unique wave design to cover the goods and or services, or even a unique or arbitrary existing word that they can use as their brand going forwards. So we're going to do another quick poll just to see if you understand the distinctiveness versus descriptiveness concept. So a client approached us and he would like to know if he can register food market to cover a supermarket. So do you think this is possible? So sorry, the mark is Foodland and he wants to cover supermarket. So please choose yes or no. So we need to remember here whether we think that Foodland will be too descriptive of the goods and services to be covered by a supermarket. Very well done. So all of you got it correct. So yes, the answer is no. This is definitely an example of the type of application that will be rejected by the OPO, as the goods and services would be seen as being too descriptive of the name that they would want to register. So once Bristol Barrel is confident that their mark will pass the distinctiveness test, they need to ensure that there's not a similar mark already registered or pending on the UK IPO's database, as a proprietor of an earlier mark may oppose the application. So this information may also help prevent accidental or critical adoption of any mark that is the same or similar as one that is already being used by another trader for the same or similar products or services. So it will be possible for you to do this type of pre-filing search yourself, but this is a service that we often assist clients with, as the process of filtering through the various registered trademarks can be daunting if you're not familiar with the IPO's database and do not have the required knowledge to apply the correct filters to ensure the most accurate results. So just to give you an idea, in 2019, the IPO registered 95,000 trademarks. So if you do your searches, you can sit with a high volume of search results to sift through. And if you do not know how to use the function correctly, it can be quite a daunting task. So it is definitely something we help clients with. So we will do the searches and we will provide the client with a search report, which will highlight any similar marks that we found out or that we came across on the IPO's website. And then we will also give sort of advice on the next steps for the client. So the search results will, however, be more accurate if it can be limited to the goods and services to be covered by the trademark. And my colleague Francesca will discuss this in a bit more detail.
Yes, thank you, Susan. Hello, everyone. As you can see, I'm in quite a big room, so hopefully you can hear me fine. I'm going to take you through in a bit more detail about the trademark application. Ideally, you want to start thinking about your application a few months before launching your product or your service. And after you've decided on which type of trademark you'd like to register, in order to carry out the pre-filing search that Susan was referring to, the next key step would be to prepare a statement of the goods or services that you would like to seek protection in. This is known as the specification for the trademark application. Now, drafting the specification can be tricky and it is a critical step. So ideally, it should be done by an expert, especially where it's not clear which class certain goods or services can fall under. This is something that we would normally assist our clients with. Intellectual property offices worldwide use a trademark classification system that groups similar goods or services together in 45 different classes. This system is referred to as the NICE classification. Each class contains a list of terms, and they cover all the goods or services included in that class. Goods are in classes 1 to 34, while services are in classes 35 to 45. And for every good, there will be a corresponding service. All of the classes will have a broad heading that will explain generally what is covered in a particular class. But the heading does not include, obviously, a list of all of the goods or services in that class. This will fall under the actual specification drafting, which we can absolutely assist with. The UK IPO does offer as well an online searching tool that you use for searching and classifying goods or services to apply for when registering a trademark. As I've said, it's crucial to choose the correct class and terms. This is because your trademark will only be protected for the goods or services that you select in your application, and you will not be able to add extra goods or services once the application has been filed. So yes, ideally you'd want to seek professional assistance to draft that specification. Another pitfall that is good to avoid is in terms of how wide the specification is going to be. So it's a fine line to be threaded. That's because you want the specification to be comprehensive enough that it covers not only the products of immediate interest to you, but also products that you anticipate may be of future interest. So including classes that you think you'll want to expand your brand into can save you time and money. So to think about it, trademark lasts for 10 years. My colleague Charlotte is going to go into a bit more detail on that. But since it lasts for 10 years, it's a good idea to think at the outset about how you think your brand is going to expand within this time. Whilst thinking about this, it's good to avoid drafting your specification so widely that it covers goods or services which you do not realistically intend to market in. This is because having a very wide specification can risk the validity of your mark and your mark becoming vulnerable to an attack post-registration. Registered trademarks can be revoked either wholly or partially if they're not used for a continuous period of 5 years. It's also good to know that when you go to file a trademark application, you have to take a statement that says your mark is in use in relation to the goods or services you've specified, or that you have a good faith intention to use that mark in that way. So practically speaking, to use the Bristol Barrel case study that Susan was discussing earlier, the main activities that they were contemplating, or that they might think of contemplating in the future, were offering both guided and non-guided surf lessons, operating a surf shop, offering surfwear, wetsuits, surfboards and wax. And then perhaps in the future, we can say that they could consider opening a cafe offering food on the premises. So in this example, a few relevant classes would be class 41, which is a services class, and it covers sports and fitness services, education and training services relating to sports, and rental of sports equipment. Class 35, which again is a services class, and it covers retail services in relation to sporting goods and equipment. Classes 25 and 28, these are goods classes, and they include surfwear, wetsuits and surfboards. Class 4, which is again is for goods and includes wax for surfboards. Or class 43, which is a services class, and it's for cafe services. Now we're going to do a quick poll to test whether you've been listening to me. Let's consider that you file an application for your trademark in class 25, which covers clothing, footwear and headgear. And a year later, you decide to expand your brand into handbags, which are covered under class 18. Can you modify your application to add new classes? Let me know, yes or no. Let's have a look. Yes, okay, 63% no, well done, I'll take that. 38% of you, you can do better. My colleague Charlotte is now going to take you into a bit more detail on the timeline for a trademark application.
Thank you, Francesca. The next slide should set out the basic timeline for a trademark application. It is worth noting that it can take some time from the point of application to the point of registration. And if you are considering launching a product or doing a marketing campaign or a branding campaign, do have a think about bearing in mind how long it might take to go through the trademark process. It generally takes between 3 to 4 months from the point of application to the point of registration. But it should be noted that once your trademark is registered, it will actually be valid from the point at which it was filed. So just something to bear in mind. Timeline sets out briefly what happens and the various stages of the trademark process for the UK IPO. First of all, I would assist, or if you'd like to do it yourself, you're very welcome to, with the application process, which can now be done online. You can do it by paper form, but we much prefer using online, and it's quite an intuitive system. So the application is made online and payment is made at this point, and Francesca will run through the costs a little bit later. Once you've submitted your application, it will be reviewed by a trademark examiner. This can take up to 40 days. Again, just something to bear in mind in terms of the timeline process. The examiner will look at the mark and will provide its report. This report will set out whether or not they have accepted the trademark, and if they haven't, what needs to be done to rectify that. If the trademark is accepted, then that's all great. If it isn't accepted, this might be for several reasons. The first will be what Susan might have picked up on, she did, which is in relation to whether it was generic or descriptive. And this can be more difficult to overcome, but it is not impossible. So, for example, something like Compare the Market or Exceedingly Good Cakes for Mr. Kipling are both successfully registered trademarks, but did come across objections at the point at which they applied to register the mark because they were deemed too generic or descriptive. However, there is a process you can go through to obtain to overcome that objection and to say that the mark actually has obtained distinctiveness through its use, which would require providing lots of evidence in the form of a witness statement. So not impossible, but not really an easy task, and it may be better for you to start with a distinctive mark from the offset. The examiner will also come across and set out in its report similar existing marks, which may have been ones that, had you instructed us for the search report, we may also have picked up on, but they might be different. You should be aware that the examiner will inform the owners of these existing marks of the application that you're about to make. So they will receive a letter to say that these existing marks, these marks, they will receive a letter to say that this new application has been made and give you the opportunity to oppose. There is a 2-month opposition period, which is what happens once the mark has been published and the examiner has accepted it. So should the application be okay after those 2 months, the mark will be registered. If there are any issues, there may be a filing of an intention to oppose, which could extend the opposition period for 3 months. But assuming everything is okay, the mark will be registered around 2 weeks after the end of the opposition period, and this would be the registration date. You'll receive an electronic trademark certificate, which you should definitely keep a copy of because you may well need it in future. And the mark will be registered for 10 years, after which it will require renewal, but you can renew as many times as you like, subject to payment of the fees. So Francesca will talk you through now the trademark fees process.
Thank you, Charlotte. Yes, I'm just going to explain the costs in a bit more detail. For a standard online application, the filing fee is £170, and this includes the first class of goods or services you'd like your trademark to cover. And then there's an additional £50 for each extra class on top of that. Now, an alternative, if you'd like to test the waters before committing to payment of the full fee, is the Right Start service, which allows you to check the application meets the rules for registration. The upfront payments involved in the Right Start service are non-refundable, but you will have the benefit of a report telling you if your application meets the rules for registration before paying the full fees upfront. The costs for the Right Start are not particularly more expensive. It's £200 as opposed to £170 for the standard route. £200 for the filing fee, again including goods or services. And payment is broken down with 50% upfront plus 50% if you decide to go ahead with registration. And then there's again a £50 fee for each additional class. Again, 50% upfront, 50% if you'd like to go ahead with registration. It's also good to know that you can file trademark applications for a series of trademarks. For example, if you have the same logo in different colors, or you have the same word mark that you'd like to register in all uppercase or all lowercase, or a different kind of spelling. And applications of series of trademarks for 3 or more marks costs an additional £50 per mark, which you may well decide would be worth doing. Now, Charlotte is going to describe the opposition proceedings in a bit more detail.
Thank you, Francesca. I'm just going to talk through now briefly the grounds for opposing a trademark application. I'm not going to run through the formal proceedings towards a tribunal because I would hope it never gets to this stage, and it's quite a different topic in and of itself. So if it's something you'd like to know more about, do let us know, and we may provide this in another webinar. I've set out here on this slide the absolute and the relative grounds for opposing a trademark application. The absolute grounds are that the trademark is descriptive, generic, or simply not capable of registration as a trademark. It is quite possible that the examiner will pick up on this and its report anyway, but it is worth knowing that anyone could oppose a trademark application on this ground. The second ground is a relative grounds, and there are 2 limbs to this. The first is that the mark is identical to an earlier mark and is registered for goods and services similar to those for which the earlier trademark is protected, or it is similar to an earlier trademark and is registered for goods and services identical for those to which the earlier trademark is protected. The difference between identical and similar here could be, for example, that there's a different letter in the word that you're registering, but it's only different by a letter or 2. Whereas if it was identical, it would be exactly the same in both the word or in the logo or the shape or the colour. So it's just something to bear in mind. I have got a quick poll now, which hopefully test this in theory and see what we think. So just moving on to the next slide quickly. Oh, don't worry. Okay, so Bristol Barrel have registered a trademark. The trademark is registered for the classes that Francesca picked up on for those goods and services. They register their trademark, and 3 months later, they receive a letter saying that somebody is looking to trademark a mark similar to theirs, but it covers insurance and accountancy services and nothing else. Do you think Bristol Barrel might want to oppose this application? Let's see what we think. Yeah, that's good to see. Yeah, majority saying no and some are saying maybe, which I think is about right. So the reason for not wanting to oppose would be because it covers completely different goods and services. The maybes and the yeses, I can understand why that's come through, and that will be because we don't know what they might want to register in future. And if they're a big brand and they've got big outreach, they may actually find that they still think it poses a threat to their mark. But generally, if it's registered in different goods and services, it shouldn't pose much concern, but just something to bear in mind. So I'll now talk you through the process for potential opposition. So this is what happens before it goes to the formal opposition proceedings, which, as I've stated, I won't be covering today. Perfect. So existing owners can file a notice of intention to oppose. So if Bristol Barrel decided they did want to oppose, they would file what's called a TM7A. So that's a type of trademark form that you can find on the IPO website. This would extend the opposition period to 3 months, during which you would usually write to that new applicant and say, we have an existing trademark. Please, can you do something about it? Please, can you change yours? Can you withdraw your application? Can you do something? We're letting you know that if you don't do something, we will bring opposition proceedings. And what we try to do as much as possible, and certainly have done for clients in the past, is try and limit the possibility that it goes to full trademark tribunal proceedings by negotiating settlement. So there's a couple of ways we can do this. One would be to amend the goods and services specification to not cover the same goods and services, so that the marks potentially don't overlap and don't clash with each other and don't cause any issue. The other way to do it would be to remove entire classes, similar sort of way, or enter into what's called a coexistence agreement, where the parties agree to not trade or overlap in the way that they use the mark. The other one, failing all that, would be to withdraw the application at that stage to not go through the opposition proceedings. However, if there are any issues or it's just impossible, it's possible that it would have to go to formal opposition proceedings, which can be quite costly. So we do often find from experience that clients like both sides, and clients particularly do like to try and settle it before the opposition process takes place. So that's all we're going to be covering today. I think Catherine might have some questions for us.
Certainly. Just picking up on the last point that you mentioned, Charlotte, I think it's worth emphasising that where notice to oppose is given, as Charlotte said, it is quite common for the parties to then go into a process of negotiation, either to amend the applicant's application so that the other party is able to allow the application to proceed, or to negotiate terms of coexistence. And where the parties want to go down those routes, there is then a cooling off period, giving the parties sort of ample time to deal with a sort of an amicable resolution of the issues, rather than being forced to hurry along through the opposition process, which potentially will help save money, rather than having to go to the expense and trouble of progressing the opposition proceedings. So coming on to the questions, we've got a few have come in. First one, which I think Francesca is probably one for you, is you mentioned the right start process. Would you say that's the best way of filing an application?
Yes, I think it depends on the application. I'd say unless the application is watertight, so the mark is incredibly distinctive, very unique. Pre-filing searches have come out with no similar marks, in which case, then, of course, you just go for a standard route. I'd say right start process can be really, really good. It's only really £30 more expensive for the filing fee using the right start. And it allows you to have the benefit of a report before committing to the full payment. So it's definitely something that I recommend normally, as I said, unless the application is so strong that obviously it's not required. I hope that answers the question.
Yeah, I think it's really a sort of way of dipping your toe in the water. Would that be fair to say? So if you're a bit tentative about whether it's going to be accepted or not, particularly if there are issues around possible descriptiveness, then it can be a way to sort of find out what sort of reception it's going to get. The other thing probably worth mentioning on this is the examiners at the IPO are very kind of helpful on the whole, and sometimes it can be worth us sort of putting in an initial call just to sort of discuss something before even filing, and you can get a bit of a steer from them on certain issues. So that's also something that can be sort of worth considering, particularly because a lot of this sort of evaluation of applications is quite sort of qualitative, so it does sort of depend a little bit, although the examiners will sort of generally follow sort of the same sort of approach. There inevitably will be a sort of slight variations because it's all a question of opinion and view. So what one examiner might take a more sort of harsher view on something than another. So there is always a little bit of sort of luck of the draw as to who examines it, but we sort of are able to kind of anticipate a lot of the sort of problems, but unfortunately there can be no guarantees, because sometimes you'll get an examiner who comes up with something that you just no one had really sort of thought about.
Yes, exactly. But they are human beings, so there's an element of subjectiveness.
Yes.
Yeah,
indeed.
I was going to add, sorry, it's quite useful actually, because I've had it happen recently, that the trademark examiner will put their direct dial at the top of any correspondence, so you can actually pick up the phone and have a chat with them and ask them for their reasoning and what they did, well, not what they'd advise, but what they'd say the next steps are. So yeah, definitely worth listening.
Yeah, they can be quite constructive and give you kind of, although obviously it's your decision, they can give indications as to the sorts of things, particularly around drafting of specification, that they would sort of accept or what's sort of more problematic. The next question I think probably is one for Charlotte, which is obviously you'd mentioned that you can renew the trademark an unlimited number of times, but the question here is, what happens if you forget to renew your trademark, Charlotte?
Yeah, so the trademark's valid for 10 years, and you usually get a reminder 6 months before the end of that 10 years. So hopefully we'll get the reminder within those 6 months and we'll renew the mark. But there is a 6 month, well, I suppose you call it a grace period after the end of that renewal date, where you can still renew the mark. So there's sort of, I guess, a 12-month period where the renewal is open, 6 months before the date and then 6 months after it. But it is subject to some late filing fees. I think they're currently around £50. But if you missed that as well, then unfortunately the trademark would go on the register as expired or removed, and you'd have to register a new trademark. So it's worth keeping an eye on the dates, and we do remind clients of their renewal dates as much as we can, because it is important to make sure that your trademark is renewed. But it might actually be, in some cases, that after 10 years, and we've had this happen recently, after 10 years the trademark's not been used anymore, in which case it doesn't need to be renewed. So just something to bear in mind.
The other kind of practical thing is the importance of making sure that the details on the trademark register are kept up to date, because either your address might have moved, or you may have lost contact with whoever dealt with the original application, in which case it is important to update your details, because the IPO will send out reminders, but obviously if they go to the wrong address, then there is a chance that the renewal reminder won't actually arrive with the person who needs to action the renewal.
Yeah, and obviously, again, probably it's worth adding, Catherine, if FSP are down as a trademark representative, then we will receive that correspondence. So it's potentially more likely that it won't go missing because it will come to our offices. So yeah, just something else to mention.
Now, the next question I've got is, if as part of a marketing campaign we wish to remove the registered trademark symbol from our logo on the marketing material, then can we do that? And are there any issues we need to take into account? So I think the first point to make is that there are two different symbols that can be used in conjunction with a trademark. The first is the little R symbol in a circle, and the second is the TM symbol. Now, it's important that the R symbol is only used in connection or in conjunction with a registered trademark. The TM symbol can be used where the mark isn't actually registered. The reason for using either of the symbols is to indicate the fact that it's a proprietary mark, i.e. that somebody owns this mark and that therefore other people shouldn't be using the mark. There isn't a requirement that you add the symbol. I think I'm right in, is that right, Charlotte?
Yeah, I don't think you have to.
No, I don't think you have to use it, but obviously it's to your advantage to do so, particularly the R symbol, because it just says to the world, this is our mark, and in effect, don't you use it. But if you, for some reason, don't want to use either of the symbols because it doesn't work with the sort of artwork or graphics that you're sort of wanting to use, then I don't think there is an issue with that. But I guess one of the obvious issues that you need to think about if you aren't going to use the symbol is the fact that you're losing the benefit of that message that the symbol would otherwise have with it. So possibly a third party out there might see the mark and think that it was well, it's difficult to believe that someone would see a mark and think that they could use it even without the symbols, but the symbol might just reinforce the fact that it's a proprietary mark and might have a greater deterrent effect than if it's removed.
I don't know, I've got a sort of practical example if it's helpful on this one. So yeah. I know that quite a little while ago, one of our clients asked us to register the logo, which included the R symbol in it. And the examiner didn't oppose the application, but did make the valid point that the R symbol shouldn't really be used until the mark is registered. So even though he was able to register that logo with the R symbol in it, the examiner did make a point of saying you can't really use that R symbol until the mark is actually through the registration process. So yeah, just something.
Yeah. The next question I've got, possibly one for Susan, is would you recommend registering a word trademark or a logo trademark?
Good question. So I think ideally you should try and register both if you can. Fran has however indicated that it can become quite an expensive process depending on the number of classes you would like to register. So if your budget does not allow this, then it will probably be best to register the word form. So that will then be protected even if it appears in a stylized version. If you are ever concerned that your word mark will not pass the distinctiveness test, like we discussed earlier, then maybe better for you to file the mark in a stylized form, so in a logo form, as the added figurative elements will just maybe push it over the borderline to distinctiveness. So it really depends on your mark, but I think we sort of advise clients to register both if they're in a position to do so, unless there are sort of any other concerns that they might have with the actual trademark that they want to register.
Yeah, and that actually leads us quite nicely to the next question, which again, Susan, probably one for you, which is applying for a trademark worth it for a startup business?
Yeah, I think so. Just as Charlotte also demonstrated, the whole process can take quite a long time. So if you are obviously keen to have this brand protected, then it's definitely worth getting it registered. You obviously need to have an idea of what it is you would like to have covered by the trademark, but it is quite a straightforward process, and it's definitely worth getting that trademark in to make sure, just as I mentioned as well, there's so many trademarks that get registered, every year and even every day. So it's definitely worth getting your brand in as soon as you can.
Thank you. And actually, there's another one I can pick out, which is sort of on the same theme, so we might as well pick that one up at the same time, which is it risky to start using a trademark before we've registered it? Do you want to pick that one up, Susan?
So I think, just as you can't obviously use it with the R symbol at the end, so there is obviously a concern that your trademark might not make it through to registration, even though you have started using it already, but your trademark will be protected from the day you actually file it. So provided that your trademark actually goes through the examination process safely, which Charlotte indicated is about 2 or 3 months after it's been filed, and also through the opposition phase, then you can be fairly confident that it will be registered. So it is a risk because it might not be registered, but if you just keep it in mind, then you can start using it as soon as you file it. I don't know if anyone has anything to add.
I was just going to add, I guess it depends a little bit on what actually your situation is, because if you've been using a mark on an unregistered basis for a while, then the risks such as they are already there, but it's probably better if you haven't looked at registering a trademark in the past, to look at doing so sort of sooner rather than later, because the sooner you get the process started and the sooner you get a registration, the greater the protection. That's a slightly different situation to a business which is either a startup and is just starting to trade and hasn't really invested any time and effort in developing a brand, or a business which is established but is thinking of launching, say, a new product and is coming up with a brand name. In the latter situation, then if you're thinking of putting a lot of time and effort and money into a new brand and you're keen to have it registered, then it is probably sensible to do some preliminary searches to get an idea before you start using the mark as to whether a registration is going to be possible, or whether there are other people out there using the same brand. And if you're using sort of marketing or PR consultants to help you with a product launch, for example, then they may be able to give some guidance on that anyway. But certainly, the trademark searching is another tool to sort of help you make the right decisions around those kind of issues. Let's have a look. The next question that we've got, let's just have a look over that one's a bit. Yeah, this is a sort of on a slightly different subject, and it's maybe one for Charlotte. What happens about trademarks to cover Europe since Brexit?
Yes, so prior to Brexit, the EU IPO would cover UK as one of its countries that would be protected. But since Brexit, you would have to file a separate EU application if you wanted to cover your EU countries. If you had an existing EU mark prior to the 1st of January of this year, the UK IPO actually created an equivalent EU a UK equivalent mark based on your EU registration. So if you had an EU mark prior to the 1st of January, you'll now have an EU mark that excludes the UK and a corresponding UK mark. But it is worth bearing in mind that they will now need to be renewed separately. Also worth mentioning that for, I guess, understandable reasons, we used to be able to, as a firm, register EU marks, but we're now unable to because they have precluded UK qualified lawyers from doing this and providing this service. But it is something we can assist with. We have contacts who can do it for you. Does that help? Anything else to add?
No, I think that's helpful, Charlotte. Yeah, just to say, we no longer handle EU trademarks, but we have a firm of trademark agents, an external firm that we work with very closely, both for handling EU filings and also filings around the rest of the world. Our agents in turn have a network of international agents that they use for international applications, but it's certainly something that we can help with. As you can probably imagine, once you start thinking about filing in multiple territories, the fees can mount up quite quickly, but it is, obviously something that may need considering depending on where you are. It's usually best, if you are thinking of going down the international route, to have a sort of a priority list, so focusing on the territories that are most significant to you in the first instance, and tackling those first. And if those applications are successful, for example in the UK and the EU, then thinking about registering further afield. But obviously it does sort of vary from one business to another. One other question that I'll just pick up, because it's it's a different thing, but it's sort of related to, it's got a sort of foreign element to it, is the question of, can you register foreign words as trademarks? And the answer to this, from sort of my past experience, is yes, but you do need to be careful, because the examiners can be quite cute when it comes to foreign words. An example might sort of illustrate this. I had a client a few years ago which was a producer of Japanese food, and they had a number of trademarks registered for various Japanese words, and some of them had sort of got registered quite smoothly. We had one application where they had a new brand that they wanted to promote, and we filed the application without, I have to admit, checking what the English translation of this particular word was. And it turned out that I think it was some sort of rice product. And the examiner obviously went to Google Translate or the Japanese dictionary and discovered that this word was indeed a word for rice or rice product or something. And so we were able to complete the registration, but there were a few terms in the application, which in the specification, that we had to delete because we couldn't get over the descriptiveness angle. But I guess, I mean, that was a bit of an odd one. Probably more often a foreign word might be used in relation to something quite different to what the word actually means in English, in which case there shouldn't be a problem. I think that's probably all the questions, maybe one or two, but they're sort of the ones that they're sort of covering the points that we've already covered. But I think that's probably everything. So unless there are any other questions, that probably just leaves me to sort of wrap things up for today. Just to remind you, if you have got a moment at the end of this session, please do complete the feedback survey that will pop up shortly. Would appreciate your feedback, and you never know, you might be the winner of the John Lewis vouchers. If you've got any other questions arising from today's session, please do email us. We'd be happy to talk about whatever's kind of concerning you on a no obligation basis. Very happy to do that. Also, if you're interested in receiving legal updates from us, we have a number of regular newsletters which you can subscribe for. So yeah, please do get in touch if there's anything we can help with. Thank you very much again for attending today's session. I hope you found it useful, and look forward to seeing you again before too long. Thank you.
Cheers, everyone.